Hi, I'm Whitney Sorrell Law Firm, Scottsdale, Arizona. Thanks for tuning in to Whitney's Tax Files. Today I'm handling some frequently asked questions. This question concerns a client that asks, what are the different methods and what's the difference between the different methods of taking title to property? For example, they were asked, should we take title as tenants-in-common, as joint tenants, or as community property with rights of survivorship? So, tenants-in-common is where two people might own an undivided interest in a property. If two people come together, they each own a 50% undivided interest as tenants in common. Joint tenants is where, similar to tenants in common, but if one person were to die, the joint tenant has what's called rights of survivorship, and the joint tenant then would own the entire piece of property. Whereas in tenants in common, if one person dies, that person's will or trust would say where that person's half of interest goes. Now, community property with rights of survivorship is similar to joint tenants, except this would be between husband and wife only, and in a community property state. Now, the reason why you would want to own something as community property with rights of survivorship instead of as joint tenants is because there are tax advantages. It's called a double step up in basis. We can talk about that another time. But there are tax advantages afforded only to married couples for having property titled in this way. So I hope this answers your questions. Again, thanks for tuning in to Whitney's Tax Files.